Fela in Malawi, Season 2. And once again, I have a very special guest, the one and only Modecai Msisha, Senior Counsel. How are you, sir?
I'm all right, and how are you?
I'm fine, fine. Thank you for coming on. It's very exciting. As we were talking off camera, this is the second season of Fela in Malawi, a podcast where we try and shine a light on interesting Malawis that are doing interesting things and hopefully have constructive conversations, which maybe the typical Malawian would not be able to have on an everyday basis. So to start us off, obviously most people would know you because you were the face, I would say, because you did say yourself in the media that it was an entire team that won the last re-election case, or the election case itself. But who are you, Modecai Msisha, as Senior Counsel? Maybe give us a brief background as to who you are, and we'll take the conversation from there.
Oh, well, one of those Malawians that grew up partly in Zimbabwe, and then for the greater part in Malawi. Went to school for 1 year in my village in Rumpi in Chena, then went to secondary school at Shaminade in Karonga, some 5 years there, then 1 year of waiting for selection to university, then ended up at Chichiri, which was Chancellor College then, where Chichiri Secondary School is.
Okay.
Yeah, I did a year there. Went to Mpemba to join the law course. Then the university was merged into one institution in Zomba, and we moved to Zomba and completed the process there. So that's pretty much the formal side. I have 4 children and 1 granddaughter. So it's a pretty exciting life that I think I have had, a privileged one.
And still going. Awesome. So that's interesting to say that, when we look at respected individuals such as yourself, we only see the tail end. So I would say I think predominantly the people that watch the podcast so far are millennials, quite a few Generation Z, surprisingly, but we see someone like yourself as just a tail end. So you said, even someone like yourself, you had to wait a year in between selection. What did you do during that year? What was your thought process at the time when you were waiting for selection?
For selection into university. Malawi went through a transformation during that time. They decided they were going to add standard 8, otherwise schools and primary school ended at it's for university you're talking about.
Yes.
Yeah, okay. We still had to wait a year because there was a transition happening from taking on completion of secondary school at Form 4 and Form 5. I think they were moving from Form 4 into Form 5.
Yes.
So they were merging 2 classes. So I had to wait 1 year and not know which way things were going to go. It was a difficult year because you had 1 year of doing almost nothing. So you learn to do a few things. You learn to pick up a couple of mischiefs here and there to keep yourself going. Okay. And then eventually, it's time to go, and you go. But it did shape my life to some extent because I was dissatisfied with the fact that I and many others had to go through that period of waste, which I think was not informed entirely by educational considerations, but had some political aspects to it. Yep.
And what effect? You said that you were dissatisfied. So what did you do with that dissatisfaction, or was that a motivator in any sense for you going forward?
I think it created a certain amount of animosity towards the institutions of state. Uh-huh. And I think I've borne a bit of that in me going forward. It goes on to this day. I am inherently a suspicious person when it comes to dealing with the state.
As most lawyers apparently are, suspicious in nature anyway, whether the state or otherwise. Can I ask then, so what was the reason that you decided to study law then? What made that the career path?
Okay, that was pretty accidental. When I was at Chancellor College Chichiri, I was largely a science student with language, English, literature, and whatever, because I loved language, and I could write well even then. So my thinking then was probably I'll end up in either medicine or something in the sciences field. I think I was particularly good at chemistry and biology. So, I was not too serious as a student, but sufficiently motivated to keep going. So I thought I would end up probably in the medical field. Then one day when I was starting the second year, I came in from holiday, got to Chancellor College at Chichiri, and it was evident I was being looked for. So the messengers at the main foyer, etc., said, "Oh, you're Mr. Msisha?" Yes. Okay. The registrar wants you, and they say as soon as you get here, you must go to the office and meet him. So right, I went over to the office and introduced myself. It was on an evening, we're arriving at college on an evening. And then the registrar went around phoning the principal, the provost, the dean. It was like, wow, there must be something going on that I was not aware of. Yeah. And then, right, we all sat down and they pulled out the Vanguard. I think the Chancellor College had a student magazine called the Vanguard. Mm-hmm. They pulled it out and said, "This article here, did you write it?" And I looked at it and said, "Yeah, that was like last year." I said, "Yeah, what exactly did you mean?" The article was headed, "The Old versus the Young." Mm-hmm. So what exactly did you mean by it? Oh, I can't quite remember now, but I'd have to read it, etc., etc. That session went on a couple of hours, at the end of which it was declared that I had been expelled from the university. Really? And I was to go home. So it was...
Okay. Can I ask, do you recall, because it was the old versus the young, can you recall the actual substance of the article, what you actually...
The substance was really criticizing the constant tickling of young people by this system. Mm-hmm. Like, oh, you should consider yourself lucky, you go on buses to go to school, like we're privileged. And I was saying, we're not privileged. Times have changed. Mm-hmm. You folks might have had to walk 10 miles, but now there is a bus that covers that 10. I'm not going to walk because you walk 10. Mm-hmm. I want to use the bus. So it's simply changing times. And I think it was taken as if I was... I think that particular description of walking, I think probably was taken as a reference to Dr. Banda having walked to South Africa, that part of his history. And so I think that's how they saw it. Mm-hmm. So they felt offended. It was like I was attacking the leader.
Mm. And so from there, where does the story go from you being expelled?
Well, fine. And I went home. The advice was, you should go to your home village, because I think if you hang around town, you're likely to be detained because the system is focused on you at the moment. So
at that point in time, it really was a system where if you were seen as going out of line, the repercussions could be quite severe.
Absolutely, yeah, mm-hmm. Absolutely. So I said, no. I'm expelled. Just take me to Nderande, where I live with my brother, and I'll deal with myself going forward. I'll figure out what to do. So I went to Nderande and spent some time there. I think I was seriously considering what everyone did in those days is find a way to get into Tanzania and get into exile and continue with education. But fortunately for me, I had very good lecturers in the English, the languages department, because I think I was particularly good with languages. And I think when they heard the story, they heard that I'd been expelled, they kind of put together a team of people to protest at what had happened. Mm-hmm. So the university did do a bit of noise making, which led to the vice chancellor then, Dr. Ian Michael, calling me to the university office for a discussion about my situation. So we had a chat and I told him what had happened, what I thought about the article, etc. And they said, well, he'll do what he can to approach the system to try and get me back, but he can't promise anything. So I went home again. Then he called again and said, I have something to discuss with you. I went over and he said, the matter is apparently with the president. So he has asked. No, he has actually said he is not interested in you coming back into college because you've been a troublemaker for quite a while. In secondary school, you led some protests at Rumpi Secondary School, and he's aware of that. I said, well, I was never at Rumpi Secondary School. I was at Shaminadi Secondary School. So he said, oh, great. I'm going to go back to him. So I went back and said, this is the situation. I think there is confusion. It's not him. Then he called me back and said, the president says, are you willing to meet a team of cabinet ministers to talk through your article? And the vice chancellor, I must give it to him. It was extremely courageous for him to pursue this issue. And I don't think many of our own folks would have done it. But he was a Briton, and he felt very strongly about academic independence, etc. So I was invited on an appointed date to meet 3 ministers at the Malawi Congress Party national headquarters, which was at Chichiri, which then was headed by Mr. Muaro Nyomayo. So being invited to that place always sent jitters to anybody. But that was where the meeting took place, and we went in. There was the 3 ministers. I think my recollection probably later Lekebanda must have been one. I can't remember the other 2. Then there was the vice chancellor and the principal, Dr. Mwanza. They sat in the corner and the session started, and it just went on and on, and question after question, basically quite hostile. And I did my best to defend the article line by line. Then at the end, they said, all right, we're done. You'll hear from us. You can go. And I said, gentlemen, and I could see the vice chancellor just like squirming, like, what are you going to say again? I said, you've been asking me questions, so the story you're going to carry from here depends on the questions you asked. Can I speak without responding to a question? So they consulted and said, okay, go ahead. So I did give them an address on my understanding of academic freedom, and that when one writes, one is not attacking anybody. One is just dealing with issues that might be in the air. So that's all I was doing. And this is not the first article I've done. I've done quite a few articles, and they all address some issue that I think is kind of pertinent. So it was okay, fine.
May I ask, how old were you when you were giving this address?
I should be about 21, thereabouts, yeah.
Because I'm not to take you off the path of the conversation. It's just for me, I want to put a pin in that, because I'm quite taken aback at the fact that at the age of 21, I mean, now it makes sense. You know, we see you giving addresses all the time. That's your profession. But at the age of 21, you were bold enough to give that address in front of cabinet ministers, and also to do that at that time where, you know, the time was much more hostile, I think, the repercussions. So what gave you the courage, or how exactly were you able to do that?
At that point, I think it was a matter of life and death. It was survival. You know, sitting, saying, either I get back into college, or I will end up across the border in Tanzania or Zambia, Russia, Cuba, etc. That's what everyone did, was under political scrutiny and hostile action. So I had to do the best I could. And
okay, that's quite amazing. So please continue. So you're giving the address?
Yeah, then I think it was 2 weeks later, the vice chancellor called me and said, they've agreed you can come back to college, so you can come back. But he said to me, I know you're not, you're doing the sciences, but I have a feeling if you go back to Chichiri, probably you'll last a few months and the system will arrest you, you'll end up in detention. Would you mind going to Mpemba, where the law school was, and do law? I hadn't thought about that, but I said, okay, fine. That's fine, I'll do it. So he called the principal at Mpemba, got me admitted into the law school without, obviously, prior interview and all that. I went there 1 term late, and that's how I embarked on the study of law. But sometimes some little regrets, but generally, I think I went the right way. I found a lot of fulfillment in the law, which I might not have found in any other profession.
That's true. I mean, it's always easy for other people. The beauty about this podcast and these conversations I have with people is that, you know, you listen to people who you think are very accomplished. So it's very interesting for me to hear you say, oh, sometimes some regrets, because from an objective standpoint, if someone was to ask you, or was to ask me, do you think, Modecai Msisha SC has any regrets about studying law? They would be like, why on earth would that happen? But I think from our standpoint, not only do we think it was a good thing, but I think we're quite grateful for the fact that that happened. And it's a running theme I see in life where, as you said, for you it was a mistake. But sometimes, I am a Christian myself, sometimes it's interesting how the most unfortunate circumstances can still lead you in a path which leads down the path that you have been on. And that's quite profound. I would like to touch on one or two things before we continue that you've brought up, which are screaming at me. You discussed academic independence, academic freedom, and you said, for the people in academia to stand by you and to take those risks, you thought that that's something which, you said your folks might not have done. I find that so interesting to say that so many years ago, that is there. Let me not ask a close-ended question. Do you feel that has changed? Do you feel like academic freedom has moved forward from that time to now? Do you feel that the academics now are as brave as those that assisted you at that time?
I think a lot has changed, not necessarily because academicians have risen to the cause and grappled with and fought for academic freedom. I think it was more or less handed over to them by the political processes and changes that happened in 92 to 94. When you look at the time I was in college, the books that you had in the library that you could access were quite limited. There's certain things you knew about, but they would not be available. So we were striving for knowledge, we're striving to know. And lecturers spoke to you in hushed tones on certain issues, kind of make sure all is well before they make whatever statements they would like to communicate with the students. Now we've moved to a situation where this freedom is kind of taken for granted. It's not because it's essential that there be academic freedom. I think it's just like, well, it's there. You have to strive with people to get informed. I think we don't have as much of the culture that says, I need to know, I need to probe, I need to scrutinize, because that's what academics is about. So in some ways, we've made a lot of gains. But what I'm saying is the gains are not necessarily because academia fought for them, but rather people at some point said, I think we've had enough of being sat upon. We need to flex some muscle. And when that political change happened, then academia became a beneficiary. But I think they do need to sit down and consciously talk about the importance of academic freedom and why, unless we get that as a core value of the educational system, we're never going to get a truly informed populace. We're never going to get innovation, whether technical, political, economic, just the thinking that you get from the feeling that you can and you should and you have no one to thank for the right to think, the right to probe, and the right to keep pushing the barriers.
The reason I asked that was it was also premised on something you had said earlier. The heart of the issue that led you into that tough situation was the title of that article, which was Old versus Young. It's something which appears to still be happening today. When I talk to people of my peers, and when I just the thing about social media is, even when I don't talk to people, when I open it up, you kind of get a feeling of the day. But the feeling of the day, I say that with quotation marks because, for example, I consume Twitter the most. Twitter is a very interesting sphere of individuals. I cannot say it's the wider Malawi because, one, you have to look at how many Malawians have cell phones for me to consider that to be, the wider Malawi. And then two, how many of those people are on Twitter versus Facebook and the like. So I use that very cautiously. But that being said, I think a lot of that same, the heart of that article still lives on, where people say, we are made to feel happy for sometimes very little. So it's like, someone gets a job and you're an employer yourself, so I'm going to approach with caution. And they say the employer pays, say, a graduate 50,000 kwacha, right? And they're expected to make their way to the office, do all the things, and take care of themselves and find a place to stay. And then, after say some years, someone says, okay, I want an increase, or the work I've put in, and then the person says, oh, you should be thankful you have a job, because in my day, even having a job was a privilege. So I would say the scales, and this is hypothetical, the scales I think have shifted. But I find it interesting because in my view, I think the heart of that article still exists today, where not just old versus young as the title, but that the times have changed. And to an extent, our generation may have a bit of entitlement, but I think there is a middle ground where the entitlement ends, and then it's like, we cannot, if you walked, that doesn't mean that I should walk, because now things are more accessible. There are buses everywhere. I don't know, what are your thoughts on that? Do you think that that is a case, or do you have a different view on whether that old versus young still exists in 2021?
Oh, it does exist, although the entitlement aspect is a problem.
It is, yeah.
Because you, not in a comparative way, but in trying to understand how we progress in life. When I consider where I started, how I started, the circumstances, the difficulties, and these were challenges that one had to meet in order to get on in life. And then, granted that things have changed to a much better situation now, there's more prosperity, you do have a sense that people think by virtue of attaining this, I must have certain minimums.
Yeah.
That is probably a false premise. It should be, by virtue of what I've attained, I am capable of doing more as me. I need your support in order to get on. Obviously, you have to have a springboard. You can't start from absolutely nothing. So there's got to be a balance between the idealistic young person that wants everything now, and the one that says, the older person that says, well, who's going to fund?
Exactly. Yeah.
So if a balance has to be found, but the answer is certainly not, oh, well, because I suffered, then you must suffer. No, that we can't. A society cannot move forward if we keep on pulling ourselves back and using history, unfortunate history, as a basis for determining where we should be now.
Yeah. I think that's the case, because I see the issue with law, I would like to say, is that it forces you to think on both sides of the argument. I would like to think anyway. And for that reason, I would like to say that I do try my best to look at things both sides. And I think at the moment, like what you're saying, is that we have two opposite sides that are not willing to meet in the middle. It's an extreme, I would say, entitlement, then the extreme, I suffered, and it's hard to find the space where those two can meet and have a meaningful discussion. To say, because your question, your response is, who's going to fund that? But if the individual, say, is bringing the work, I can only think in terms of our profession, but if the person is bringing in the work that they're bringing in, and they're billing and they're fulfilling their contract to you, in my view, that should be rewarded, and should not just be a case of, oh no, I'm going to make you suffer for 3 years because that's how long it took me to get my big break. But maybe look at the merit and the time. So I think what you said is very, very profound, very true, that what you have attained makes you capable of everything, of whatever you want to attain. But, we need to find that middle ground. I think that was a very powerful thing that you said there. I want to move forward in the story, because from there, so now you're at law school. I don't know, is there anything you want to discuss from your time in law school that was maybe that stood out to you before you ventured into practice?
Well, law school was difficult because I missed the first term. And all the students in my class, except two, me and retired Chief Justice Anastasia Msisha, were outsiders. The others had been at staff training at the Institute of Public Administration at Mpemba, which was part of the university. So they dealt with civil servants and kind of legalistic involvement. So they had a sense of law getting into law school. Me and Mrs. Msisha, she came from Bunda, I came from Chichiri, with no background of legalistic thinking. She had the benefit of starting from phase one, day one. I went in after missing one whole term. So just catching up, understanding the concepts was an extremely difficult undertaking.
Because it's an entire way of thinking, not just learning.
Yes. And then get a book and read it, and the next day talk. We used the case method at that time. So you had to read up on your cases, and in class the following day, you had to discuss what this case meant and etc., etc. So you're starting from nowhere and trying to understand what judgments mean, what certain arguments mean. That was quite difficult. But once I got into the flow of things, it was a lively experience with the classes were very small. My class had 7 people. Mm-hmm. The class ahead of me, I think had 3 people. Okay. The class behind probably had 5. So those were very small classes. So there's no way you could sit there and do nothing, because you were 8. You were 8 with the teacher, and the teacher is saying, "Okay, right, let's talk about this." You had to participate. That was very good. The case method, I think, was very good in teaching thinking and analysis, not just pick a chunk and say, "Oh, this was said." You need to figure out why that was said and what it means. Yes. So the case method of teaching law for me was, as opposed to the lecture method, was extremely, extremely useful, and I hope more and more of that can be used, because you get involvement and you also get law students to understand what's involved. Going through college, law school, I think there was one experience where, coming from end of year holiday, you come back and your name is not on the people that have passed. It's like, "Oh, you failed a course." So, right, I failed a course. What did I fail? Oh, father said, "I think I failed civil procedure." And I was really baffled. And I said, "No, it cannot be correct." And so I went, challenged the situation. And I remember Dr. Boyson, I think he was the dean then. I think he reviewed the situation, and then we had a meeting, and he said to me, "Please just write this up, the supplemental exam, just write it." So why don't you take the paper so we can go through it and you can show me where I went wrong? He wasn't the lecturer, it was someone else. So, and that someone was from outside the college. Okay, yeah. that was coming in to help with the teaching, a highly placed person. So I got the impression that Dr. Anda was saying to me, "I've looked at the paper, you probably didn't fail, but look, just write this up." So my argument was, if I write this up and fail, for the same reason that I failed, I did not fail, but I failed, what next? No, you're not going to fail, please just write this up. So, all right, I wrote this up and went through. Graduating, yeah, I think we didn't have anyone with a distinction. We had probably 2 with credits, and I was one of them. So it turned out pretty good for me. Yeah, it was tough sell, but it was enjoyable. Mm-hmm. Yeah.
Everything worthwhile is a tough sell sometimes. I would like to think I just want to bring to light something you've said, because you've spoken about a number of things already. You've spoken about the transitional periods that were there during your education. And what I'm gleaning from what you're saying is the fact that whether, I don't think it was predestined or you thought about it at the time, but you were able to traverse the difficult times. So it wasn't as if it was a quick path to senior counsel, is basically what I'm trying to say. I'm saying that because there's a lot of unrest currently with the COVID situation. People who are studying in schools, they're feeling as though they are in a non-ideal situation of education, and I've seen a lot of people complaining, they're having to do things via distance, and they're not getting the benefit of speaking with the lecturer and so on and so forth. But I think to hone in on what you've said, which I think is important in the current time set, is that we are once again in a time of transition. And if you were able to get through it, I'd like to put a word of encouragement and say, I think we can all find a way, as we are all, even those of us who are now in industry, finding ways to cope as the world changes, because the world never stays the same. So I just wanted to put that out there as we proceed. So there are 2 things, because of time, that I really want to discuss before we get into the questions that were asked. I know I said it would take about an hour.
No problem.
The first thing was practice in one-party rule. how was that? My understanding is that you have quite a few interesting stories from then, and you also have the benefit of having practice during that time and practice in present day. So could you maybe tell us about that?
Well, you had a regime in place that said over and over, lawyers are liars. Yet the system needed lawyers. You cannot carry on a governmental system without some lawyers, whatever you think about them. So, sitting as a government lawyer, you understood your obligation to behave. That raised the challenge where you're simply going to take orders and do what you're told to do. I faced a few of those situations when I was a legal aid advocate where the boss says you shall do the following, and I say I can't do that one because it's not the correct thing, and I've assessed it. It can't be the correct thing to do. Well, it's an instruction. I always said no. If you ask me to do that which I know is wrong, I won't do it. You can do it. It created quite some tension, but I think it was the right position to take. I then became a state advocate, prosecuted a couple of cases. At that time, all the important, really, truly important political or capital punishment cases went to the traditional courts where we did not practice. So we dealt with the cases that were below the capital punishment.
That was where it was smoke and fire rule.
Yeah, the traditional word, yes, yeah. So.
Oh, sorry, for those, I've been accused in the past of when I'm knowledgeable about something, not taking the time to explain that for the purpose of those watching. So you can correct me where I'm wrong, but this is from what I've learned, was that in those days, so the separation was where you were practicing was law, obviously with the restrictions you have talked about. In the traditional courts, where it was, in essence, the system was trying to get rid of people, to my understanding, the no smoke without fire rule was that once someone had accused you, there's no smoke without fire, so it was almost like a foregone conclusion that you were guilty upon.
I think the proposition was you've got 1 million people and they pick on 1 out of 1 million. Surely there's got to be a basis for that. Mm-hmm. So you can't stand there and proclaim innocence when out of everyone you were picked as the guilty one. That was the essence of it, which is obviously horrific, yes. But
it goes against the basis of what defending yourself in law should be.
But the court did utter those statements, and the court, when it was at the appeal level, the traditional court, had a magistrate on it. So there was a lawyer there. Mm-hmm. They made sure there was a lawyer. I think his job was probably to write what the chief said, decided, and give it the best light legally. So, but if you utter statements like, well, there's no smoke without fire, well, everyone heard it, and that is the way the court tended to proceed. As time kind of went on, the law person on the panel, the magistrate, depending on his inclination, he would try to ameliorate the worst excesses of the system. Mm-hmm. But the chiefs had the show. They got their way because they decided by vote. So the magistrate really had to do persuasion, but I was not a decision maker. So that was a terrible part of our practicing of the development of the law. One must look back and say, well, where did this come from? Sadly, for me, looking back, when I was at primary school in my village in Rumpi, the only minister I saw face to face as a kid before the cabinet crisis of 1964 was Dr. Nchirwa, and he was the Minister of Justice. He came to open a traditional court at my village. So he was the Minister of Justice. So they were in the forefront of setting up this system that they thought was going to dispense justice in the true sense of the word, as opposed to technical justice according to the written law. Well, in the end, it's the same system that was used to get a lot of people into prison and ironically, Otonchiro was one of the persons that was tried under the traditional court system, convicted, appealed, failed, and got sentenced to death. So there is a lesson that getting excited about certain idealistic things without considering the possible adverse implications is something that we must all be on our toes, guarding against. Yes. So yeah, that was the traditional court system. I think it was a tragedy for the country, and one hears murmurings of, it's a good idea to set up some traditional courts as long as they are under the high court system. Maybe there's some merit in there, but one should caution against taking steps that are intended to address one little problem here, another little problem there in the legal system, as opposed to dealing with the broad philosophical basis upon which the legal system, the court system, is based.
So a piecemeal approach as opposed to a holistic. The piecemeal can affect the whole in the end. All right. So going back, you said you were at the state advocates and you were prosecuting a number of cases.
Yeah, I at least I had the privilege of seeing it on both sides as legal aid advocate, defense, prosecutor. Did succeed in a couple of cases, but my view was always, based on what I read about these things, was I am not the agent for sending people to jail. I'm an agent for bringing to the court's attention all the strong points that I can against the accused person. But without trying to sink the accused person, it's not my job to do that. So that's how I always approach these cases. And I think it worked for me because I have no sense of guilt, like maybe someone went to jail because I pushed an agenda, including beginning to collude with the investigating authorities to just try to get a conviction. That was never part of my way of looking at it. So I have a clear conscience.
Would you think that is prevalent today?
I think it happens. I think it's happening so much. It's a serious embarrassment that you hear of courts here and there where people get arrested, and they're arrested in Blantyre, but they're taken to some outlying court outside the city, and what goes on there is all unusual, but it ends with either some payment is made in order to avoid a certain adverse consequence like imprisonment. So these things are happening, and we seem unable to do anything about them, which is tragic. Now, getting into private practice under the MCP regime, I started off private practice with Subjan and Company. So good experience in terms of learning the tricks of the trade. But again, in terms of what you could do, there were limits. There's some things you simply did not touch because they would lead to consequences from the political system. So we dealt with business side of things, rarely into the criminal field, rarely into cases that had some political connotation. Not unique to Subjan and Company, it was the whole profession. That's how they dealt with these situations until the time when a few of us decided it is time to challenge certain premises. It's time to try and push a bit, and we did. But I'll tell you an interesting situation where because the courts sometimes take the view that they solved Malawi's problems. No, they were quite timid. But a situation where I think we're suing the city of Blantyre for some order that they'd made, which was obviously legally wrong, etc. And everyone was kind of scared to challenge it. They challenged it in court, and the court kind of ignored the matter, pushed it, and the court said, well, we cannot adjudicate on this matter, full stop, that's it. And so what kind of judgment is that? At least say something legalistic to squeeze out. But it was basically, no, we're not going to touch this matter. So there was a bit of cowardice across the board, in the judiciary, at the bar, and in the populace at large. So as lawyers, there were very courageous people within the profession, but there was a lot of that realism, like, you know what, you tackle something like this or something like that, you probably end up in trouble, so don't do it. But somebody had to start doing it to try and get change to happen. Yeah.
And so eventually, enough of you did it, and I guess the rest is history. Would that be an apt summary, or?
The Malawi Law Society eventually started getting bolder and bolder, and we started having conferences to talk about human rights, funded by donors, talk about human rights. The word that was never produced in Malawi, human rights. You never talked about human. You could talk about the criminal justice system, anything else, but don't mention human rights. But eventually we started mentioning human rights, and I think that was part of the beginning of the movement for change in this country.
Something which I was told a long time ago and I've never tested. Do we have a word for human rights in our local languages as of yet?
The word that was being used then was ufuru wachibadudwe. It's a bit of a mouthful.
Yeah.
I think there's no harm in crafting a word. I always admire the way Nyerere with Swahili, if he had a word that needed to be used in Swahili but didn't exist in Swahili, he took a foreign word and used it. So oxygen, oxygeni. You make it Swahili and that's it. People have a meaning for it. So we just need to find a word that captures human rights, and it is simple and can be pronounced in vernacular.
Yeah. So if you're from the north like me, it'll be human rights. Okay. Let's move forward because of time. I'm really enjoying this conversation. So we are going to fast forward now, because now from this we'll have a few broad questions which I think will tackle some of the things I think people wanted to hear about. I wanted to ask you now. So you have been, as you said, suspicious of the state and those things, and I've seen you've been someone who's not been shy to tackle issues when you see they are there. What was it like when you got the brief to say, okay, we are taking on this election, knowing the past of how election cases have been tried? I think we can speak openly now to say there have been times where we've seen that they've almost been shut down prematurely, not given the chance to be properly adjudicated. And I have seen in the last 4 or 5 years a real change. I'd like to hear from you as well. A real change in how the courts, and maybe it's almost like a second wind, maybe from what happened with the Law Society back then. I'm sure there have been many winds during the time, but a fourth, fifth wind, where it seemed you and the other lawyers were bold enough to say, if we don't tackle this now, it will continue to happen, where these irregularities will be prevalent. So what was it like when you got that brief and said, okay, this time we're doing it, and what was going through your mind? Let me end there.
So you're referring to the election case that just went on in Lilongwe. I had a couple of approaches from here and there, etc. And frankly, my initial reaction was, you know what, stuff this country. I have been through the business of trying to give my thoughts and my views and my time to support positions and philosophies, political and otherwise, that were for the common good. But it looks like the common good has a different meaning for people once they have who they want in a position of power, or they are in power themselves. So I think my initial reaction was, I really don't want to get involved. I spent a lot of time, 93, 94, in the political legal arena, and the end result was simply not acceptable. It was like a total negation of everything that we talked about, trying to bring about change, and eventually achieving that change from one party to multi-party, and then first multi-party elections, etc. So I was reluctant, but then a couple of more approaches, etc., and I could see there is a problem. And the reason I could see there is a problem is because in the last election, before the one that went to court in Lilongwe, there was again an issue in court where I was engaged by Macra, but rather by, what is this? The electoral board, MEC. I was engaged by MEC to act for them. And I did appear for MEC when we had this hearing that went on into the night, and eventually we had a judgment in the night, etc. I was arguing MEC's position, which happened to suit the then government, DPP. I think they were happy with the arguments I was putting forward for MEC's obligations, rights, etc., etc. So the result went the way it did. So I was aware that the arguments I had made then had had some sway with the judge and delivered a particular result, which was basically, well, there's been a decision, the president has been sworn in, you can't stop the swearing in. That must happen at a certain time frame. Then you can do the challenges after, which was always thought like, oh, once they're in power, there's really nothing you can do to remove them.
So it's almost like that was the
that's the end of it. Yeah.
Once we get them sworn in,
that's it. So I felt I did have an obligation to try and support the proposition that the remedies don't end when someone is sworn into office. The remedies remain and we can pursue them. So eventually I think that would have moved me to say, okay, I will get involved, provided there are people to work with that are going to do the researches and get the evidence in place, etc. And then I want to do my best to present the best points about our client's situation. So but I thought it'd probably be a month and we'll be done. And then, right, you got in there and you were stuck in there.
For a while.
But there were times when I regretted just being imprisoned in the situation. But by and large, I thought I developed a lot of respect about the support team that were working on putting the evidence together, allowing and putting the issues before me so I could look through them and decide what we can pursue, what we shouldn't. It was all very cordial, very respectful. You argued about issues, but they understood that ultimately if you have a team leader or a number of team leaders, you must allow them to take the final decision on what is going to be done, and they'll tell you the reasons, of course, and then eventually, if you have your leading counsel, you must allow him to say that I will do that, I'm uncomfortable, we can't do this, etc., etc. So it was a very cordial, intense effort at analysis and getting the facts, issues, the legal issues, the law, the constitutional issues together. Then, of course, you had to develop the ability to present those issues in a way that made sense to the court, which you also had your eye on the public. This was being beamed. And one thing that I kind of think was important in this case, although I opposed it initially because of time issues, is the beaming to the public. The fact that the public followed this case, they followed the evidence, they followed the arguments, I think was a huge impetus on the whole system to deliver the correct judgment. I am not saying the judges would have gone a different way, but I still think the fact that everyone knows, people have heard, and people have reached certain just conclusions about the state of the evidence. You can't suddenly say something that was totally unsupported by what the people had heard. So it does say it's important for the justice system to ensure maximum publicity for proceedings where there are important and topical issues so that people can follow what is going on. So I'm all for broadcasting judicial proceedings because it does put that positive pressure on everyone to get to the correct decision.
It goes with that saying that justice must not just be done, but must be seen to be done.
Absolutely.
I think that leads into that as well. Obviously, as a lawyer, and in advocacy, you're taught you're not supposed to get emotionally invested, and you as you said, you had acted on behalf of MEC in the past, and this time you took on another brief, and but I would like to know, maybe succinctly as possible, what was the feeling when you finally got the judgment and you had realized that the team and yourself had done something historic, because it's the first time we overturned an election outside of Kenya, but the first time in Malawi, and it's very rare. What was that feeling in that, after the entire circus and the feelings of regret that had that had crept in between the entire process?
I must say there was a lot of respect for the 5 judges for arriving what I was convinced was the correct decision. There was also a lot of humility in having been part of the process of persuading the court to reach the correct decision. And there's also then a lot of trepidation about, right, this is done, what next? Now you're marrying the legal process to the political situation. What's going to happen? And no doubt that was an issue that, for those of us who are in court, we never address that. We're just dealing with, we got to get this right. So you get it right, and then you're faced with what's going to happen next. And that you get so much uncertainty, and you get the fear of, well, you could be unraveling the entire legal political system in the country. And so what are you going to do about it? So you try and comment as little as possible and be as fair as possible to all interests in the matter. So yes, there was a lot of feeling of elation that the client had been heard, that I had contributed in expounding the legal principles, constitutional principles that were necessary for arriving at a correct decision, but quite a bit of worry. You go home and it's like, okay, you've made friends and enemies.
Yes.
What next? I mean, I met a lot of people that were friendly. I also met a lot of people that you could tell were just totally, you were the culprit, you were responsible for this. But so what? Things need to be done that have to be done.
I think so. I think that leads back to maybe at the beginning of your career when you talked about being at the state advocate, where at the end of the day, if you are, as you have said so eloquently, if you're able to put forward the points that in your view were the best points to put forward, it's not like you were trying to sink anyone, but it was about putting forward those best points, and they were seen to be just at that point in time. That being said, because of time, we're going to move to the question section. I'm just going to read the questions, about 6 or so. These were taken across